The Code of Civil Procedure operates as a series of interlocking gears. Navigating the AIBE syllabus requires viewing these sections not as isolated rules, but as a predictable procedural flowchart. This crash course isolates the 8 most heavily weighted topics in the code, translating dense legal requirements into straightforward language. The CPC is strictly procedural law. It provides no substantive rights. It only dictates the mechanical steps required to enforce the rights defined elsewhere. Mastering this chronological life cycle, from the first filing to the final recovery, provides the structural foundation needed to answer AIBE questions with precision. We begin with Topic 1, the vocabulary of the court. The most tested distinction exists between a decree and an order. A decree conclusively determines the substantive rights of the parties, the final resolution of the controversy. An order is a formal decision on procedural or intermediate steps during the trial. These definitions dictate your appellate strategy. Every decree is appealable as a matter of right. Orders, however, are generally not appealable unless they are specifically listed under Section 104 or Order 43 of the Code. You must also distinguish a decree from a judgment. A judgment is the statement given by the judge explaining the grounds of a decree or order. Think J for justification and D for decision. The judgment contains the reasoning. The decree is the executable outcome. 2 more definitions frequently appear. A legal representative is anyone who legally represents a deceased person's estate, including those who intermeddle with it. Mez profits are the profits a wrongful possessor actually received or could have received, but take note, these profits exclude any value added by improvements the illegal occupier made to the property. Topic 2 focuses on jurisdiction. Section 9 mandates that civil courts have the authority to try all civil suits unless expressly or impliedly barred. When suits are barred, the court usually applies the finality rules of res subjudice or res judicata. Section 10, or res subjudice, stops concurrent courts from holding parallel trials on the same active issue. Section 11, or res judicata, prevents courts from trying an issue already heard and finally decided. One stops simultaneous litigation, the other prevents the revival of dead disputes. Order 2 Rules 1 and 2 enforce this finality by requiring a plaintiff to include their entire claim in a single suit. If a plaintiff omits a portion of their claim or fails to pray for all reliefs without explicit court permission, they lose the right to sue for that portion forever. The Supreme Court addressed implied jurisdictional bars in Gundaji, Satwaji, Shinde. When a civil suit involved determining if a person was an agriculturalist, the court ruled the issue belonged exclusively to the mamladar. Remember, Gundaji means go to the mamladar. Regarding Section 10, the Indian Bank case clarified that res subjudice only bars the trial of a subsequent suit, not its institution. This allows a bank to file a summary suit and seek judgment, even if an ordinary suit is pending, provided the defendant hasn't been granted leave to defend. In Iftikhar Ahmed, the court established that res judicata applies even between co-plaintiffs. If a conflict of interest existed between them in a prior suit, and deciding that conflict was necessary to provide relief, that decision is final and binding in any future case. Constructive res judicata, found in Explanation 4 of Section 11, was tested in State of UP versus Nawab Hussain. A dismissed officer failed in a writ petition, then filed a civil suit raising a new constitutional ground. The court barred the suit, ruling any ground that might and ought to have been raised in the first proceeding cannot be reserved for later. Remember, Naya ground nahi chalega. C.A. Balakrishnan further demonstrates that the public policy of Order 2 Rule 2 applies to writ petitions. A litigant cannot seek restoration of possession through a writ while a civil suit for the same cause of action is pending or decreed. These strict rules ensure that litigants cannot circumvent the system by splitting claims or attempting to relitigate issues that have already been decided. Topic 3 deals with the place of suing. Section 15 establishes an administrative rule for pecuniary jurisdiction, requiring every suit to be filed in the court of the lowest grade competent to try it. Territorial jurisdiction is decided by the nature of the dispute. Sections 16 through 18 mandate that suits for immovable property be filed where the property is located. Section 19 governs movable property and torts, allowing the plaintiff to choose between where the wrong happened or where the defendant lives. For contracts and general disputes, Section 20 allows filing where the cause of action arises or where the defendant resides. Note the Section 21 trap. Any objection to the place of suing must be raised at the earliest possible opportunity, or it will be waived. We move to Topic 4, execution. This is the stage where the court translates a written decree into the actual recovery of property or money from the judgment debtor. Section 60 identifies what can be attached and sold. It also lists vital exemptions. Wearing apparel, cooking vessels, beds, the tools of an artisan, and seed grain of an agriculturalist are absolutely exempt from attachment. Section 62 provides physical protections for the home. No seizure can occur between sunset and sunrise. Outer doors cannot be broken unless entry is refused, and pertinician women must be given notice and time to withdraw before officers enter their rooms. A favorable decree only translates into recovery when paired with the correct jurisdictional choice and a mastery of execution exemptions. Topic 5 involves suits by or against the government. Section 79 dictates the naming convention. Use Union of India for the central government and the name of the state for local governments. Section 80 requires a 2-month written notice before filing a suit against the state. While Section 82A allows for urgent relief with court leave, no interim order can be issued without hearing the government first. This 2-month notice period is excluded when calculating the limitation period for the suit. Topic 6 covers appeals. Section 96 allows a first appeal as a matter of right, reviewing both findings of fact and law. However, a second appeal under Section 100 is strictly limited. A second appeal only lies on a substantial question of law. Chunilal v. Mehta defines this as a question that is of general public importance, directly affects the rights of the parties, or remains unsettled by the highest court. It is not a platform to re-argue simple facts. In Kapisetti Venkatratnam, the Supreme Court ruled that high courts cannot act as a third trial court. They are prohibited from setting aside concurrent findings of fact unless they first formulate a substantial question of law. Order 41, Rule 27 restricts additional evidence on appeal to very specific circumstances, such as when the trial court wrongly refused the evidence or it was impossible to produce despite due diligence. As seen in Gill & Company, the rule is no late homework. The appellate framework is designed to rectify judicial errors of law, but it provides no remedy for a party's failure to present their case properly at trial. Topic 7 outlines 3 corrective remedies. Under Section 113, reference, a subordinate court refers a question regarding a law's validity to the High Court. Section 115 is revision, used by the High Court to correct jurisdictional errors when no appeal is available. Section 114 and Order 47 provide for review, allowing the same court to reconsider its own decision to correct an error apparent on the face of the record. The Haridas Das Case clarifies that a review is not an appeal in disguise. It is limited to self-evident errors that do not require elaborate argument to establish. Topic 8 is Section 151, Inherent Powers. These are procedural powers used to ensure the ends of justice, but they cannot be invoked if an express provision of the CPC already covers the situation. As shown in Mahant Ram Das, Section 151 is a flexible power. It allows the court to prevent the abuse of its process and correct injustices that the rigid rules of the code might otherwise permit. Section 151 acts as the procedural safety valve, ensuring the court can act in the interests of justice when the written rules are silent. Let's consolidate. A civil suit moves through a defined life cycle. It begins with the definitions of decrees and orders, proceeds through strict rules of pecuniary and territorial jurisdiction, moves to the implementation phase of execution, and allows for correction through a limited appellate hierarchy. Focus your final review on the high probability areas, the distinction between Section 10 and 11, the mandatory notice requirements of Section 80, and the legal standards for a second appeal under Section 100. Utilize the primary case law memory tricks. Gundaji is the Mamlatdar, Indian Bank allows summary suits to be instituted, and Nawab Hussain means you cannot bring a naya ground if it could be raised before. The Code of Civil Procedure is a rigid framework of procedural discipline. Trust the structural logic of these modules to navigate the AIBE